Payback times.
The phone spins on the hardwood floor like a compass that has lost its north. I watch it from the bed, still sitting against the headboard, coffee going cold on the nightstand. The automated voice keeps reading, calm, genderless, unbothered the way only machines can be when they're delivering catastrophe. Claim 3, the method of Claim 1, wherein the adaptive mapping algorithm dynamically recalibrates sensory substitution parameters in response to user specific neural feedback patterns at intervals of no less than. I know the next 11 words before it says them. I wrote them at 2 in the morning, 14 months ago, in the green covered lab notebook I keep in the fireproof lockbox in my closet. I get off the bed. My feet find the floor. I pick up the phone, which has cracked diagonally across the lower left corner. A small, clean fracture, very precise, and I put it back to my ear. Applicant of record, Ashford Innovations LLC. Inventor of record, Damon R. Ashford. I end the call. I stand in my bedroom in the thin grey light of a Thursday morning. The city not yet fully awake outside my window, and I feel something move through me that I don't have a name for at first. It isn't panic. Panic is fast and hot. This is the opposite. A sudden spreading cold. The way you feel when you step into a lake in November and the water closes over your ankles and the only thought you have is perfectly clear and perfectly still. This is going to require everything I have. I set the phone on the nightstand. I pick up my coffee, I drink it cold. Then I go to work. My home office is the second bedroom I converted 3 years ago, and it is not a neat room. It is a working room, which is different. Whiteboards on 2 walls cover engineering diagrams and legal notation. Styles that shift depending on which part of my brain was dominant when I wrote each line. A standing desk I almost never stand at. Filing cabinets that contain files organized in a system only I understand. The partnership agreement is in the second drawer of the left cabinet, in a manila folder labeled NB Founding Docs, executed. I remember exactly where I put it 4 years ago, after the closing dinner with Damon, when we'd had good Barolo and talked about where NeuralBridge would be in a decade. I remember thinking then that the legal paperwork was the least interesting part of what we were building, that the technology was what mattered. 41 years old, formerly of Hartman and Schofield LLP, 8 years drafting IP agreements that protected other people's inventions, and I had left my own founding documents in a drawer and thought about wine. I spread the agreement on my desk and read it the way I should have read it 4 years ago, slowly, section by section, with a yellow highlighter and a legal pad beside me. The IP clause is on page 14, section 8.3. I read it twice, then a third time, each pass tightening something in my chest. All intellectual, property developed in connection with the operations of NeuralBridge Technologies, including but not limited to inventions, software, processes, and methods, shall be considered company property and owned by NeuralBridge Technologies LLC. 11 lines. No definition of developed in connection with. No specification of whether company property means equally owned by both partners or controlled by the managing partner, which the agreement defines on page 7 as Damon. No provision addressing pre-existing IP I brought to the company. No clause governing dissolution, acquisition, or what happens if one partner decides to route company assets through a personal holding entity. I had spent the spring of 2016 drafting an IP assignment clause for a medical device startup that ran to 3.5 pages. I had included definitions for prior IP, company IP, derivative IP, and jointly developed IP. I had included a schedule requiring each founder to list pre-existing inventions. I had included a reversion clause if the company dissolved without an acquisition event. The clients had been two brothers in their late 20s who had never read a contract in their lives, and they had trusted me to protect them. And here was section 8.3, 11 lines, my own signature on page 42. I sit with that for a moment. The irony lands heavy when it's also your fault, without any comedy whatsoever. But here is what I know, and what keeps the cold feeling useful rather than paralyzing. Ambiguity in an IP clause does not mean Damon wins. Ambiguity means the clause will be interpreted, and interpretation requires a court to look at conduct, intent, contribution, and context. And in this case, the context is going to be a problem for Damon Ashford, a significant problem. I pull out a fresh legal pad and write a single line at the top, what I can prove. Then I start making a list. The adaptive neural interface was my invention, not a collaboration, not a joint effort, mine in the specific legal sense that patent law cares about. I conceived the idea, I reduced it to practice, I did the technical work. Damon's contribution to NeuralBridge's research and development was funding introductions and telling investors a compelling story about the technology. He is a gifted salesman and an able CEO, and, it now appears, a thief. Those things are not mutually exclusive. I have the green lab notebooks, 4 of them in sequence, covering the development period from initial conception through prototype testing. Dated, signed, witnessed. I had kept them in proper invention disclosure format out of professional habit even after I stopped practicing law. Lab notebooks carry evidentiary weight in patent proceedings because they're hard to fabricate retroactively when they've been properly kept. Mine had been signed and dated by my research assistant, Lin Tao, who initialed each page after I completed it. A habit Lin found eccentric until I explained why. I suspected Lin would remember that conversation. I have code commits. Every significant development in the algorithm is time-stamped in our GitHub repository, committed under my username with comments written in my notation style. The repository is private, but I have access, and more importantly, the metadata doesn't lie. I have emails, hundreds of them, starting from a message I sent Damon on March 3rd of 3 years ago, the subject line reading, "Breakthrough Need to Talk," in which I described the core adaptive mapping concept in enough detail that a person of ordinary skill in the art could have understood what I was claiming. Followed by dozens more explaining refinements, describing test results, asking him to keep the details confidential until we filed. Asking him to keep the details confidential, I closed my eyes briefly. He had taken notes. I do not call Damon. I do not text him. I do not alert him in any way that the automated notification service I set up has done its job this morning. Whatever advantage I have right now is the advantage of knowing something he doesn't know I know, and I intend to keep it. I shower, dress, drink a real cup of coffee, and at 8:15 I send a message to Renata Osei-Mensah on Signal. We had been associates together at Hartman and Schofield. She was 3 years ahead of me, brilliant and precise in the way that makes senior partners both admire and slightly fear someone. She made partner 5 years ago and now runs their IP litigation practice. More importantly, she is the person I trust most in the legal world, and she understands patent procedure the way most people understand the native language, without having to think about it consciously. The message reads, "I need a secure call. Today, if possible, it's significant." Her response comes in 7 minutes, 11 a.m. She includes a video link. I spend the intervening hours doing what I said I would do. I go back to work. I pull up the algorithm iteration I was running when the phone rang, and I sit with it, running the next sequence, making notes, doing the job I came to NeuralBridge to do. This sounds counterintuitive. It is not. If Damon is monitoring our shared systems, and I have to assume he might be, I want today to look like every other Thursday. I want my access logs, my email activity, my calendar to read as completely normal. The element of surprise is the only procedural advantage I have at this stage, and I will not trade it for the emotional satisfaction of making him know that I know. My hands do not shake. I find that interesting. At 11, Renata's face fills my laptop screen. She is in her office, jacket on, despite the fact that she is clearly working from home. Her background gives it away. The edge of a bookshelf with the kind of personal objects nobody brings to an actual office. But she has put on her jacket because she treats video calls like meetings, and it is one of the dozen things I have always respected about her. "Talk to me," she says without preamble. I tell her everything. I read her the application number, the filing date, the title, the applicant, the inventor of record. I watch her face do the thing that faces do when a professional is processing information they find both alarming and interesting. "Pull up the filing," she says, already open. We go through it together, Renata asking questions, me answering them. Her expression stays controlled, but I can hear in the quality of her silence what she thinks. Finally, she says, "He filed this through Ashford Innovations LLC. His personal holding company, not through NeuralBridge. No. So he's not even claiming this on behalf of the company you co-founded. He's claiming it personally." "Yes," she sits back. "Priya, walk me through your IP assignment clause." I read her section 8.3. The silence on her end is the particular silence of a senior IP partner who has seen this before and finds it professionally infuriating. 11 lines, she says. Finally, 11 lines? You drafted this? No, Damon's attorney drafted it. I reviewed it. I pause. I signed it. She absorbs that. Okay, here's where you are. She leans forward again, elbows on her desk. The good news is that ambiguous IP assignment clauses get litigated regularly, and the outcome depends heavily on evidence of inventorship and conduct of the parties. You have lab notebooks? 4, properly kept, initialed by my research assistant on every page. Timestamped code? GitHub, under my username, going back to initial conception. Correspondence establishing you as the technical mind behind this? Hundreds of emails, including a message to Damon describing the core concept 18 months before his filing date. Something shifts in her expression. Not quite a smile. Okay, the bad news. She holds up one finger. He filed 3 weeks ago, which means he's in the early examination phase. The USPTO moves at its own pace, but if the examiner finds the claims allowable and issues a notice of allowance, the patent issues in his name, I finish, and then you're fighting to correct inventorship on an issued patent rather than challenging it pre-issuance. It can be done. It has been done, but it's harder, more expensive, and the clock starts running on your ability to seek certain remedies. She pauses. How long ago did you say his filing date was? 3 weeks. You have time. Not unlimited time, but time. She looks at me directly through the screen. Are you prepared to move fast? I'm already moving. She nods. The mechanism we'd pursue is a derivation proceeding under the AIA, the America Invents Act. You file with the USPTO, claiming that the named inventor derived the invention from you. You need clear and convincing evidence. She tilts her head. Based on what you've just described, I think you have it. But I want to see everything. Every notebook, every commit log, every email. I want to build a timeline so airtight it reads like a documentary film. I'll have it to you by end of week. Good. She pauses. Priya, I need to ask you something. Ask. Is there any argument, any reasonable argument that Damon contributed to this invention, even in a minor way? Even reviewing drafts, suggesting directions, anything that could be characterized as inventive contribution? I think about this carefully because Renata is asking me to think about it carefully, and because she is right to. Inventorship is a legal concept with a specific meaning. It is not about who worked hardest or contributed most to the project. An inventor, in the patent sense, is someone who conceived of at least one claim. Contribution to reduction to practice, building the thing, testing it, funding it, does not make someone an inventor if they didn't contribute to conception. Damon reviewed my technical summaries, I say. He asked questions in meetings. He once suggested we test the algorithm with a broader range of sensory inputs, which was a direction I had already independently pursued and documented 2 months prior. He did not conceive of any claim. He does not understand the technology at a mechanistic level. He can explain it to investors in a way that makes them feel like they understand it. That is not inventorship. Renata nods slowly. Okay, that's what I needed to hear, and more importantly, that's what your documentation needs to show. She pauses. One more thing, the declaration of inventorship he filed. I haven't finished reading it. Read it tonight. Specifically, look at whether he filed a declaration under 37 CFR 1.63. If he signed a standard oath of inventorship, he declared under penalty of perjury that he is the original inventor. She lets that sentence sit between us for a moment. If you can prove he isn't, he hasn't just filed a fraudulent patent claim, I say. He has committed fraud on the USPTO. She says it quietly, which is a federal crime. I nod. My voice, when it comes, is steady. I'll call you Friday. After I end the call, I sit for a moment in the quiet of my office. Outside, the city is fully awake now. I can hear the coffee shop 2 floors below my building, the espresso machine, the rumble of a delivery truck. Normal sounds, Thursday sounds. I open the USPTO filing on my screen and scroll to the declaration section. It is there as Renata predicted. 2 pages, standard form 37, CFR 1.63, dated 6 days ago. And at the bottom, above the signature line, the standard oath language that every patent attorney explains to every client before they sign. The language I used to read aloud to clients in the conference room at Hartman and Schofield. The language I can recite from memory because I read it so many times that it is simply part of me. I hereby declare that I am the original inventor of the claimed invention. His signature, bold, slanted, the signature of a man who had never doubted his right to occupy any space he chose to occupy. I look at it for a long time. Damon Ashford has not only stolen my invention, he has signed a sworn statement to a federal agency declaring that he created something I created, and he has done it knowing that every significant technical development in our company's history lives in my notebooks, my code, my emails, and the memory of every researcher who has ever watched me work. I get up and go to the closet. I take the fireproof lockbox off the shelf and open it with the combination I have not written down anywhere because some things you simply keep in your own head. Inside, 4 green lab notebooks, a USB drive with offline backups, and the original executed copy of the NeuralBridge founding documents. I carry everything to the desk. Then I go to the bookcase along the south wall, where my law school textbooks are lined up beside more recent treatises, Chisholm on patents, Moyes Walker on patents, a well-worn copy of Patent It Yourself that I keep for sentimental reasons and occasionally find useful. I pull Chisholm Volume 3. I pull my copy of the MPEP. I stack them beside the lab notebooks. I make a pot of fresh coffee. I sit down at my desk, surrounded by the accumulated evidence of what I actually built, and I open the legal pad to a fresh page. At the top, I write 2 columns. On the left, what he filed. On the right, what I can prove. The left column will be the shorter one. I pick up my pen and I begin. The first rule of asymmetric warfare is that the side with less firepower cannot afford to telegraph its moves. I learned that not in law school, but from my father, who played chess with the intensity of a man who believed the game was a metaphor for everything. He said it while moving his knight in a way that looked like a retreat. 3 moves later, he had my queen. I was 11. I did not forget. For 48 hours after Renata's call, I do not retreat. I appear to retreat. I show up at NeuralBridge's offices at my normal time, say good morning to the people I always say good morning to, drink the terrible coffee from the third floor machine because I always drink the terrible coffee from the third floor machine, and I sit at my desk working on the compression algorithm while conducting, in parallel, the most thorough document audit of my life. The trick is that my hands are always visible, doing one thing while my mind is doing another. I have always been good at this. Damon used to call it my superpower in investor meetings. Priya can be in 3 places at once. And I would smile and say something modest. What I was actually doing was thinking about claim language. I start with the shared drive. Everything accessible under my login, I export. Every email thread in the shared NeuralBridge account, every Slack archive I can pull, every version of every document in our collaborative folders. I do this from my work laptop during normal working hours because unusual after hours access might trigger a system flag if Damon has set any up. I work methodically, folder by folder, saving encrypted copies to a personal drive that never touches a NeuralBridge server. On the second day, I discover the locked folder. It appears on the shared drive sometime Tuesday afternoon, while I am in a team stand-up about the third quarter development roadmap. A new folder inside the executive documents directory labeled simply Corporate Restructuring, Ashford, logged to his credentials. I stare at it for less than 2 seconds, then look back at the meeting screen. After the stand-up, Marcus Delgado lingers on the video call. He is our lead software engineer, 34 years old, meticulous in the way that people who genuinely love code tend to be. He cares about elegant solutions the way I care about precise language. He has worked directly under my technical direction for 3 years. "Hey," he says when everyone else has dropped off the call. "Did you see the new folder?" "I did." "What's that about?" I look at him through the screen. Marcus has a good face for reading, open, honest, not practiced at concealing things. One of the qualities I appreciate in an engineer and would be concerned about in an adversary. "I'm not sure yet," I say carefully. "Did Damon mention anything to you?" "He said something in the team meeting yesterday about streamlining the co-founder structure." Marcus pauses, which I thought was a weird thing to say. "It was a weird thing to say, Priya." He drops his voice, even though we are both alone in our respective spaces. "Is something going on?" I make a decision, not the full conversation, not yet, but enough to keep the thread open. "I'm looking into some things. Can we talk Friday?" In person, not on any company system. The pause on his end is the pause of someone who has just understood that the question itself is significant. "Yeah," he says. "Of course." I note privately that he does not ask me to use the NeuralBridge Slack to coordinate. He already understands. On Wednesday evening, I drive across the city to Renata's firm. The innovation district where NeuralBridge lives is all glass and exposed steel and food trucks parked outside buildings that used to be warehouses. It has energy, and I have always liked its energy, but tonight I'm glad to be leaving it. Renata's firm occupies the 14th floor of a building that has been a law firm building for 40 years, and it shows in the best possible way. Solid, quiet, carpeted in a way that absorbs sound and signal seriousness. Her assistant has gone home. Renata lets me in herself and leads me to a conference room where she has already spread documents across the far end of the table. A legal pad, a printed copy of Damon's patent filing, and 2 mugs of tea that are still steaming, which means she timed my arrival exactly. I sit across from her, and for the first time in 4 days, I let some of the containment go. Not all of it, but enough. "You look like you haven't slept," she says. "I've slept. I've also built a document archive that a forensic accountant would be proud of." "Good. She wraps both hands around her mug. Let's talk about your options. She lays them out the way she always used to lay out case strategy, sequentially, clearly, without false reassurance. That quality alone is worth more than I can say right now. I do not need someone to tell me it will be fine. I need someone to tell me exactly what we are dealing with. You have two parallel tracks, she says. The first is administrative, an inventorship correction petition to the United States Patent and Trademark Office under 35 United States Code, Section 256. If successful, the USPTO corrects the patent to either add you as co-inventor, remove Damon as sole inventor, or both, depending on what we can prove. She looks at me directly. Given your documentation, I think we can prove you are the sole inventor. Damon's claim to any inventive contribution is not supportable. It's not, I confirm. He reviewed summaries. He didn't conceive anything. The second track is civil litigation, fraud, breach of fiduciary duty, unjust enrichment. She taps her pen on the legal pad, and depending on how the USPTO responds to the oath issue, we may have grounds for a criminal referral to the Office of Enrollment and Discipline. The false declaration he signed, if we prove he knew he wasn't the inventor, is fraud on a federal agency. I already knew this, had already turned it over in my mind from every angle, but hearing Renata say it calmly in a quiet conference room at 9 in the evening makes it real in a different way. Damon signed that oath. He held a pen and wrote his name beneath a statement swearing he was the original inventor of something I created, and he did it, I believe, with full knowledge of what he was doing. There's a third element, Renata continues, Biosynth Medical. Their due diligence request. She looks up from her notes. You know about that? I pulled every email before he could lock me out. They sent a chain of title inquiry last Friday. I pause. He hasn't responded yet. Renata is quiet for a moment in the way that means she is recalculating. Priya, if he responds to Biosynth's due diligence request and certifies clean intellectual property chain of title, he adds another layer of fraud exposure. And if he doesn't respond or stalls, Biosynth starts asking questions on their own. She sits back. The licensing deal is a pressure point. It's the pressure point, I say. The $3 million royalty is the reason for all of this. He needs that patent in his personal holding company's name to route the royalties away from NeuralBridge, away from me, and into Ashford Innovations. She nods slowly, which also explains the operating agreement amendment. I had sent her a copy the night before. Another thing I found in my document review, buried in the state business registry filings, a unilateral amendment to NeuralBridge's operating agreement signed only by Damon in his capacity as managing partner, granting himself sole signing authority over intellectual property licensing transactions. He filed that without your signature, Renata says. He filed that without my signature. Your partnership agreement requires mutual consent for material amendments. I've read Section 12. She makes a note. That filing is a breach. It may also constitute fraudulent misrepresentation to the state, depending on what certification language the registry requires. She looks at me over her reading glasses. He's not being careful, Priya. He's being fast. Those are not the same thing. He is being fast because Biosynth is close to signing. He wants the royalty structure locked before anyone looks too closely. He probably thought I would not. Check the patent alert service. Or perhaps he thought his filing would be obscure enough, routed through the personal LLC, that I would not immediately recognize my own claim language. He knows me as a technologist. He seems to have forgotten I am also a lawyer. That, I think, is his central miscalculation. Renata and I built the two-phase plan over the next 2 hours. Phase 1 is silence. Authenticate and organize every piece of evidence, obtain sworn declarations, file nothing, say nothing. Phase 2 is simultaneous and overwhelming. We will file the inventorship correction petition with the USPTO, serve the civil complaint on Damon personally, and critically notify Biosynth Medical's legal team that the patent's inventorship is under active challenge and that any licensing agreement executed before resolution of the dispute would carry significant legal risk for them. The simultaneity matters, Renata says. If he gets even 12 hours of warning before Biosynth knows, he can call their counsel and spin a story. We do not give him 12 minutes. Agreed. I look at the timeline she has sketched on the legal pad. How long for phase 1? 10 days, maybe 12. She meets my eyes. Can you hold it together that long? I've been holding it together since Thursday morning. She studies me for a moment. Then she does something she almost never does. She smiles. Yes, she says. You have. I drive home through city streets that are quieter now. The food trucks folded up and the glass buildings lit from inside like lanterns. I am thinking about what Renata said about provisional applications. She brought it up while explaining how the situation could have been prevented. And though I know this territory as well as I know my own handwriting, hearing it framed as instruction rather than regret gave it new texture. If I had filed a provisional patent application in my own name at the moment of conception, the March night when I sent Damon that email with the subject line, "Breakthrough Need to Talk," I would have established priority as the inventor with the USPTO itself. Provisionals are inexpensive and relatively simple, and they create a timestamp that is almost impossible to challenge. It is the first thing I told every client at Hartman and Schofield when they came in with a new idea. File the provisional, file it now. Do it before you tell anyone, including your partners. I did not take my own advice because I trusted my partner, and I have spent the last 4 days deciding that the trust and the advice are separate things. The advice was always correct. I think about Lindau, my former research assistant, who initialed every page of those green lab notebooks. I think about the emails on Dr. Amara Thiam's university server. I have 2 more calls to make. Marcus meets me at a coffee shop 6 blocks from the NeuralBridge offices on Friday morning. Not the one where our team goes, a quieter place, newer, that has not become anyone's habitual space yet. He is already there when I arrive, hands around an Americano, and he watches me come in with the careful attention of someone who has been thinking about this meeting since Tuesday. I sit down. I buy time with nothing, no prelude, no warm-up. I show him Damon's patent filing on my phone. I let him read the applicant name, the inventor of record, the filing date. I watch his face. He stops, reads it again. This is your algorithm, the adaptive mapping sequence. Yes. He filed this under his personal LLC 3 weeks ago. Marcos sets my phone on the table and looks at me with an expression I recognize as the specific outrage of someone who has just learned that a system they trusted was rigged. He cannot do that. He is trying to. I fold my hands on the table. Marcus, I need to tell you something about the legal exposure here, and I need you to listen carefully before you decide anything. I explain it the way Renata explained it to me, without false comfort. The fraudulent patent, if it issues unchallenged, does not just steal my royalties. It creates a chain of title problem that could allow any future litigant, a competitor, an acquirer, a licensee, to argue the patent is invalid due to incorrect inventorship. An invalid patent protects no one. NeuralBridge's core asset, the thing that makes the company worth anything, becomes a legal liability instead of a legal asset. Everyone with equity in NeuralBridge, including Marcus and his stock options, ends up holding something worth considerably less. If Damon's play works, I say, BioSynth signs a licensing deal on a potentially invalid patent. When that surfaces later, and these things surface, the deal unravels, the litigation follows, and NeuralBridge is in the middle of it with no clean documentation of who actually invented what. Marcus is quiet. He is doing what engineers do when given a problem, working through it systematically. What do you need from me? A sworn declaration that you worked under my technical direction, that the core innovations came from me, that Damon's involvement in the research and development process was limited to administrative oversight. That's true, he says immediately. All of that is factually true. I was in every technical meeting. He came in for quarterly updates and asked about commercialization timelines. A pause. He once asked me what latency in the sensory mapping layer meant. I remember. I had been in that meeting. Damon had nodded sagely at Marcus's answer and redirected to investor optics. Your declaration would carry legal weight with the USPTO. Fact witnesses with direct knowledge of the inventive process, declarations from people who watched it happen, are significant evidence in inventorship disputes. He wraps both hands around his coffee cup. The conflict is visible. His options are tied to the company's stability, and I am asking him to help upend the company's current leadership. But he is also, I have always known, fundamentally honest. It is why I hired him. I'll do it, he says. Tell me what you need and when. By Wednesday. I will send you a format through a personal email, nothing on company systems. He nods. Then, Priya. Is he going to figure out what we are doing? Not before we are ready for him to. Dr. Amara Thayam teaches in the computer science department at Whitfield University, 20 minutes from the Innovation District, in one of those beautiful old buildings that universities keep specifically to make graduate students feel that knowledge is a serious permanent thing. She received my email Tuesday and called me Wednesday morning. And when I explained the situation, there was a silence on her end that I recognized as someone reviewing their own recollections and finding them consistent with what I had described. I have your emails, she said. I was looking for them while you were talking. March and April of 3 years ago, then again in July. You sent me draft technical specifications and asked for my feedback on the sensory substitution methodology. The university server preserves those. With original timestamps, yes. Another pause. Priya, my name is not anywhere on Damon's filing. No, you were a technical advisor, you did not invent, but you received documentation of the invention from me, timestamped 18 months before his filing date. That makes you a third-party corroborating witness with preserved records on a server neither Damon nor I control. I wait a beat. It is very difficult to argue those emails were fabricated. She agreed to provide an affidavit and to produce the university-preserved email records. When I thanked her, she said, "You gave me credit in 3 conference papers, Priya. I'm returning the favor in a way that actually matters. I have a litigator. I have a fact witness. I have a technical expert with third-party records. I have 4 Green Lab notebooks, hundreds of time-stamped emails, 3 years of code commits under my username, and an operating agreement amendment that Renata has already characterized as independently actionable. And I have Damon, who does not know any of this." He calls me into his office on Thursday afternoon. The NeuralBridge offices are open plan on the main floor with a glass-walled executive suite along the north wall. And I can see through that glass from my desk. Can see when Damon is on the phone, when he is typing, when he is looking out the window at the district below with the expression of a man calculating something. He looks out the window a lot lately. His office smells like the same coffee he has ordered from the same downtown roaster every week for 4 years. And it is the most normal thing about a conversation that is not normal at all. Sit down, he says with the easy warmth that I used to find reassuring and now reads like a performance. He comes around from behind his desk and sits in the chair across from mine, the peer positioning, the I am not using my power here posture. His grey cashmere sweater costs more than my first month's salary at Hartman and Schofield. I place my phone on the edge of his desk. When I sit, face down, as if I am simply putting it out of the way, which is what it looks like. I wanted to check in, he says. You have seemed a little quiet this week. Just focused on the compression work, I say. I am close to something. He nods, pleased, and I wonder if he has rehearsed this or if the ease is genuine, and that is the more frightening possibility. Good. Look, I wanted to give you a heads up about some conversations I have been having. He leans forward. The investors, particularly the Series A group, have been asking about our cap table structure. Whether it is clean enough for the next raise. The cap table is clean, I say pleasantly. Right. But as we scale, there is thinking about whether a leaner co-founder structure might be cleaner, more efficient for governance. He smiles. Nothing is decided. I just want you to know I am thinking about these things. I hear what he is actually saying. He is building a narrative that will justify removing me from the co-founder structure, reducing me to an employee or less before phase 2 can happen. He is trying to move faster than me without knowing I am already moving. I appreciate you thinking ahead, I say. What would that look like for my equity position? Your equity is safe, Priya. He says it with absolute confidence, the confidence of a man who considers equity to be the whole conversation. The invention stuff. Let us just say I have been handling it. The invention stuff. I look at him with what I intend to be an expression of mild collegial curiosity. Handling it how? He waves a hand. Filings, licensing structure, the biosynth relationship, all the business architecture around the technology. That is my lane. You know that. He smiles again. You just keep doing what you do best. I will do that, I say. I pick up my phone from his desk when I stand and I walk back to my desk and I sit down and I open my laptop and I begin typing an email to Renata with the subject line. He used the phrase, I have been handling it. Call me tonight. What I do not tell her in the email, because I will tell her in words, I recorded the entire conversation. 12 minutes and 43 seconds. His voice, his words, his casual certainty that he is the architect of this situation. He is not the architect of this situation. That evening, Renata confirms she has filed the inventorship correction petition with the USPTO. The civil complaint is drafted, reviewed, and ready to serve. She has sent a letter to Biosynth Medical's general counsel through a process that does not yet reveal the full scope of what we are doing, alerting them that a material question regarding the patent's chain of title has been identified and that the due diligence inquiry should be suspended pending clarification. Biosynth's counsel, Renata informs me, responded within 2 hours asking for a call. They are worried, she says on the phone. Good. Worried licensees do not sign deals with disputed patents. Has Damon been contacted? Not yet. Process server is scheduled for 9:15 tomorrow morning at the NeuralBridge offices. You have a meeting with him at 10, yes? A quarterly review, his idea. Perfect. She pauses. Priya, tomorrow is going to be a difficult day. Are you ready? I look around my home office. The lab notebooks are stacked on the corner of the desk. The legal pad is covered in 2 columns of notes. What he filed, what I can prove, and the right column is longer, much longer than the left. On the whiteboard behind me, I have mapped the entire timeline in blue marker, from the March night of conception to this Thursday evening. Every date, every document, every witness, every moment that proves the invention is mine. My phone buzzes on the desk. I look down. Damon. A text message sent at 9:47 p.m., cheerful and unaware. Big news. Tomorrow, Biosynth deal is almost done. You are going to love the numbers. I read it twice. I set the phone face down on the desk. He has no idea that by the time he texts me again, a process server will have handed him a civil complaint in the lobby of the building he runs. He has no idea the USPTO petition was filed this afternoon. He has no idea that Biosynth's counsel is currently worried and asking questions and not signing anything. He thinks tomorrow is his day. I turn the phone over one more time and look at his message. Then I pick up the blue marker and write one more thing on the whiteboard at the bottom of the timeline, under tomorrow's date. Phase 2. I arrive at NeuralBridge at 9:45 a.m. carrying a leather portfolio, a takeout coffee, and absolutely nothing that looks like a weapon. Renata is already in the lobby, seated in one of the low chairs near the reception desk with her briefcase across her knees. She is wearing charcoal, which on her reads as deliberate, the color of someone who does not need to announce herself. She glances up when I come through the door, and we exchange the particular look of two people who have spent 2 weeks building something together and are now about to find out if it holds weight. Everything filed? I ask quietly, sitting beside her. 8:03 this morning. She pats the briefcase once. USPTO confirmation is in here. I drink my coffee. The lobby has the particular morning energy of a company that does not yet know its day is about to change. The receptionist, Jade, is scheduling something on her computer. 2 engineers from the second floor are laughing about something. Near the elevator, the espresso machine in the kitchen is running. Normal Thursday sounds. At 9:58, the front door opens and Damon comes in, already talking. He is on his phone, suit pressed, moving with the forward momentum of a man who has decided today belongs to him. He is telling someone on the call that he will have the term sheet over by noon. The Biosynth call, probably. He has not looked up yet. Then he does. He sees me first, which is the expression I expected. Easy recognition, collegial, the practiced warmth of someone who has been managing me for years without my knowing it. Then his gaze moves to Renata and the warmth stalls. Hold on, he says into the phone. He ends the call. He looks at Renata. Who is this? My attorney, I say. The lobby goes very quiet. The way spaces go quiet when the actual nature of a situation becomes clear to everyone present, including people who are not directly involved. Jade has stopped typing. One of the engineers by the elevator is no longer laughing. Damon's face does the thing I anticipated. It cycles. A fast flicker of surprise, then something he pulls down and replaces with a careful, controlled version of his normal expression. Priya. The warmth is back, recalibrated. I do not know what this is, but I think we can all go upstairs and... The conference room is fine, Renata says, standing. She says it pleasantly, the way you might suggest a restaurant. She is already moving toward the elevator. The 3 of us ride up in silence. Damon stands slightly too still, which is its own kind of movement. The NeuralBridge conference room has a glass wall that looks out over the innovation district. And in the morning light, the whole district looks ambitious and clean. The converted warehouses, the new construction, the green roofs. I have always liked that view. I sit facing it. Renata sits beside me. Damon sits across from us and straightens his jacket, which is something he does when he is recalibrating. Renata opens her briefcase. She places the civil complaint on the table, face up, and slides it across to him. She follows it with a single-page letter on USPTO letterhead, the confirmation of the inventorship correction petition filed that morning under 35 USC Section 256. "My name is Renata Osei-Mensah," she says. "I represent Dr. Priya Venkataraman in a matter involving application 18/441, filed 3 weeks ago under the name of Ashford Innovations LLC, with you listed as sole inventor of record." She pauses. "I think you know what this is about." Damon looks at the complaint. He looks at the USPTO letter. He looks at me. And for just a moment, a fraction of a second I would not have caught if I had not been watching for it, something moves across his face that is neither performed warmth nor performed calm. It is the expression of someone who has been outmaneuvered and knows it, and is not yet ready to say so. Then he leans back in his chair and he decides to try contempt. "Priya," he says my name the way you would say the name of someone who has done something disappointing. "You really think you can walk in here and take something you did not build alone? You were a cog. I made this company happen. I raised the money, I built the relationships, I got us to biosynth." He opens his hands, the gesture of a man explaining something obvious. Nobody cares who invented what. They care who runs things. The room goes very quiet. I let it stay quiet. 1 second, 2, 3, 4, 5. In those 5 seconds, I think about the green lab notebooks in the fireproof lockbox. I think about the March email with the subject line, "Breakthrough, need to talk." I think about Lin Tao's initials at the bottom of every page, patient and precise. I think about Damon asking Marcus what latency in the sensory mapping layer meant and nodding sagely at the answer. Then I open my laptop. I turn it to face him. On the screen is the Declaration of Inventorship. His signature, bold and slanted, above the oath language I can recite from memory. "I hereby declare that I am the original inventor of the claimed invention." Your signature is on a declaration of inventorship you submitted to the federal government, I say. My voice is even. Every word of it is a lie I can prove in court. Would you like to hear what the penalty for that is? Or would you like to talk about settling? Damon looks at the screen for a long moment. Then he takes out his phone and makes a call. His attorney, a man named Cliff Warden, whom I know by reputation, corporate work, not patent litigation, which is already telling, arrives 22 minutes later, still buttoning his jacket as he comes through the conference room door. He pulls Damon into the hallway for 12 minutes. When they come back in, Damon's expression has changed again. The contempt is gone. What remains is something flatter and more careful. Cliff Warden looks at Renata across the table and says, "We would like to discuss a path forward." "Good," Renata says. "So would we." She does not look at me, but I see the corner of her mouth move. Almost nothing. Enough. By 2 that afternoon, Renata has submitted to the USPTO petition file. Marcus's sworn declaration, 3 pages, methodical and precise, describing every technical meeting over 3 years in which the adaptive mapping innovations originated from me. Dr. Thiam's affidavit, accompanied by the university-preserved emails, time-stamped 18 months before Damon's filing date, showing me sharing detailed technical specifications with an external advisor, specifications that are claim for claim identical to what Damon filed. 4 Green Lab notebooks, authenticated copies with Lin Tao's initials on every page. And the recording from Damon's office, 12 minutes and 43 seconds, in which he said with unhurried confidence, "The invention stuff, Let's just say I have been handling it. That last one is not dispositive on its own, but in context with everything else, it is what my old litigation professor used to call the cherry on a very convincing sundae. The USPTO's Office of Petitions moves faster than most people expect when the evidence file is clean and well organized, which ours is. Because I spent 8 years making sure that other people's evidence files were clean and well organized, and I applied every lesson I ever learned to my own. 6 weeks after the meeting in the conference room, the office issues a requirement for Damon to show cause why his sole inventor declaration should stand. Cliff Warden calls Renata the day the requirement arrives. He does not argue the underlying merits. He says, instead, that his client would like to explore a global resolution. Renata calls me. He blinked, she says. Tell me the terms you want to open with, I say, and then tell me where you think we land. We land in roughly the same place I had mapped on the whiteboard in my home office in blue marker 6 weeks earlier. The settlement reached over 4 days of negotiation conducted entirely between the attorneys while Damon and I continue to exist in the same company, building with the particular careful courtesy of two people who have agreed to say nothing until their lawyers are done, covers the following. Priya Venkataraman is named as sole inventor of record on the corrected patent. Ashford Innovations LLC's competing application is abandoned with prejudice. Damon surrenders his equity stake in NeuralBridge at fair market valuation. A number his own Series A investors have recently recalculated downward given the cloud over the IP. He resigns as CEO effective the date of settlement execution. I retain full ownership of NeuralBridge Technologies and the patent. On the day the settlement is signed, Renata sends me a single text that reads, "Done." And then 1 minute later, "Get some sleep." I do not get sleep. I get champagne with Marcus in the NeuralBridge conference room after everyone else has gone home, looking out at the innovation district in the evening light. He raises his glass and says, "To whoever decided to keep those lab notebooks properly." "To Lin Tao's initials," I say. He laughs. Then he says carefully, "What happens now? To the company?" "The company needs a CTO," I say. "Someone who knows the technology, understands the R&D history, and can testify under oath to the origin of every innovation we have built." I look at him over my glass. Interested? Marcus is quiet for exactly the amount of time it takes him to understand that I am serious. "Yes," he says. "Absolutely yes." There is one thread the settlement does not resolve because settlements between private parties cannot resolve it. The USPTO's Office of Enrollment and Discipline opens its own inquiry into Damon's false inventor declaration 4 weeks after our petition is filed. This process operates independently. It does not ask our permission, and it does not stop when we reach a private agreement. Damon faces a disciplinary proceeding that could result in debarment from future patent practice and a referral at the discretion of the OED to the Department of Justice under 18 U.S.C. Section 1001, which governs false statements to a federal agency. Renata tells me this with the neutral tone she uses for information that is factually significant but not within our control. Biosynth Medical resumes negotiations the week after the inventorship correction is officially recorded with the USPTO. Their counsel has seen the documentation. The due diligence is thorough and clean. The licensing deal closes at $3.1 million in royalties over 5 years, with NeuralBridge as licensor and Priya Venkataraman, CEO, as signatory. I signed the closing documents in Renata's conference room, the same room where we sat at midnight 2 months ago, with 2 mugs of tea building the case from evidence and certainty. She witnesses my signature. We shake hands and then we hug because we are professionals who have also been colleagues for a long time, and some moments require more than a handshake. You should speak at the accelerator program, she says, pulling back. The founders panel. They have asked me for referrals. Ask me again in a few months, I say. She asks me again in 3 months. I say yes. The accelerator's founders panel is held in one of the converted warehouse spaces in the district. The kind of space with exposed brick and projection screens and folding chairs arranged in that deliberately informal way. That means the organizers have thought very carefully about creating an atmosphere of informality. There are 40 people in the audience, most of them early stage founders, many of them women, several of them engineers who have not yet begun to think about what happens when the technology they build intersects with the business structures they sign. I sit on the panel with 2 other founders and answer questions for an hour, and then the moderator asks if I have any advice specific to IP protection in joint ventures, because she has clearly done her homework about my year. I think about how to answer this. I could tell the story. I will not tell the full story here, not publicly, not yet. But I can tell the truth that is inside the story, the part that belongs to everyone in the room. There were 5 things I should have acted on earlier, I say. I am going to tell you what they look like because I have since learned that they are not uncommon. The room goes quiet in the way rooms go quiet when people recognize something. The first is a co-founder who avoids putting IP ownership in writing while pushing hard to move fast. Fast is important in this industry. But fast and clean are not mutually exclusive, and someone who insists they are mutually exclusive is telling you something about their intentions, whether they mean to or not. I watch people in the audience reach for their phones to take notes. I do not slow down. The second is administrative access that exceeds operational need. If your co-founder controls the legal filings, the banking, and the state registry submissions without a mutual consent requirement, read your operating agreement tonight. Read section by section. Highlight anything that gives one person unilateral authority over assets that belong to both of you. The third is a pattern of possessive language. When your partner starts referring to the invention as my technology or my product in conversations with investors, that is not ego, or rather it is ego, and it is also a signal about how they have internally categorized ownership. People speak from their mental models. Listen to the language. The fourth is resistance to outside IP counsel. In our early days, every time I suggested bringing in an independent IP attorney to review our filings and agreements, there was a reason to delay. The money was not right. The timing was not right. We should wait until after the next raise. Resistance to independent counsel, in my experience, protects whoever has the most to hide. And the fifth is a sudden interest in restructuring the company precisely when a major deal is close to closing. If your partner starts talking about cap table cleanup, streamlining the co-founder structure, or strategic realignment at the exact moment significant money is about to move, ask yourself who benefits from the restructuring. The answer to that question is the answer to a lot of other questions. The moderator asks if I would have done anything differently. Yes, I say I would have filed a provisional patent application in my own name on the day I had the core idea. Before I told anyone, before I had a partner. A provisional is inexpensive. It establishes your inventorship priority with the USPTO from that date. And it is one of the most protective things an inventor can do for themselves in the first 24 hours of having an idea worth protecting. I let that land. I spent 8 years telling other people to do that. I was so eager to build the company that I skipped it for myself. Do not skip it. Afterward, a young woman in the front row stops me on my way out. She is maybe 28, holding a business plan the way people hold things they are both proud of and afraid for. She says, I have a co-founder situation I am not sure about. Can I ask you something? You can ask me anything, I say. She asks. I answer. We talk for 20 minutes near the brick wall, next to a folding table with the remnants of the wine and cheese that someone's accelerator budget provided. She takes notes on her phone. When she leaves, she has the particular expression of someone who has just been given a map for a territory they were already worried about navigating. I drive back to the office. It is late enough that the district is quiet, the food trucks folded up, the glass buildings lit from inside. I have loved this neighborhood since we moved NeuralBridge in 3 years ago, and I love it still. More now, perhaps, because I almost lost the right to work in it on my own terms. The lab is empty at this hour. The equipment hums with the particular low-frequency presence of machines that are always running, always processing, always in some intermediate state between one iteration and the next. The walls are covered in my handwriting. The whiteboards are mine now in every sense. On the wall near the door, framed simply, is the patent certificate. The corrected version, issued 6 weeks after the USPTO accepted our petition. The paper is cream-colored and official and printed in clear black type with my name, Inventor, Priya Venkataraman, Asani, NeuralBridge Technologies LLC. I have looked at it many times in the last month. I do not take it for granted. I do not think I ever will. I sit at my workstation and open the second generation interface files. The new system is more elegant than the first. Tighter latency, broader sensory range, a recalibration mechanism I have been refining for 6 weeks that I think will change what is possible for the platform. I have been documenting every step in a new lab notebook. Green cover, same as always. Lin Tao has been coming in twice a week to witness and initial the pages, which they do with the same careful precision they always have, in the same blue pen. I pick up the notebook now and look at the cover. In my own handwriting, in the same blue marker I used on the whiteboard the night before phase 2. The date, the project title, and below it 2 words I did not write on the cover of the first notebook because I did not think I needed to. Sole inventor, Priya Venkataraman. I take a photo. I open my email and type Renata's address in the to line, and in the subject line I write, starting right this time. I attach the photo. I send it. Her response comes 4 minutes later, which means she is also working late, which surprises me not at all. Good, she writes. Just the one word. And then, below it, do not forget to file the provisional. I smile. I set the phone down. I pick up my pen, open the notebook to the next blank page, and begin writing the next claim.